Okay, welcome to Chapter 4. We're going to be talking about the business and the Constitution. So we've touched on this a little bit already when we looked at that first chapter, and we talked about judicial review and a few things. But again, I guess we're somewhat fortunate because there is an ongoing confirmation in the U.S. Senate for a new person to sit on the Supreme Court. I think that's something we can talk a little bit about. Hopefully, if you listen to this lecture live, if you are doing the hybrid and we get a chance to talk, we certainly should address some of the issues raised in those confirmation hearings. So let's talk about that Constitution. Let's take a little bit of a look at it from a business point of view. In 1787, the United States was in a bit of trouble. There were hostile foreign powers surrounding the United States. The British occupied Canada. The French occupied the Louisiana area, French and the Spanish. The Spanish were in Florida. So literally America was surrounded on three sides with the ocean for the third. So there was that pressure. There was also the pressure that following the war, there was, for want of a better word, a depression or recession that was ongoing. Several of the states, Georgia in particular, were having significant problems with the Native Americans. And there were just all these problems that were they were piling up. And in the 1770s, the Americans had adopted a constitution called the Articles of Confederation. It was a very weak, really more alliance between the colonies, later alliance between the states, than it was creating a national government. So by 1787, it was pretty clear that it either had to be dramatically reformed or a new constitution had to be put in place. Now, there was a constitutional convention, a meeting in Annapolis in 1786. They couldn't reach any major conclusions, so they agreed to meet again in Philadelphia the next year. What is, for business, what's the important thing here? Well, first of all, it's an idea that this is a federalist system. There is a federal government that is very powerful, but the states, like the state of North Carolina or the 13 states back then, had their own inherent sovereignty. They were sovereign entities. As far as business regulation, the greatest regulatory power is the ability to regulate private activity. Sometimes this is called public or police power. So, for example, you can make certain things legal or illegal. You can regulate what is a safe way to do something and what is not a safe way. You can also go down the path of regulating morality and general welfare. So the states have that great power still today. So laws can be remarkably different in regards to this regulatory power in state to state. Some states have very strong rights for consumers. California pops to mind, New York to some extent, Massachusetts. Other states have very, very weak protections for consumers. Florida, Texas, Louisiana are good examples. Also inside this federalist system, the local governments, city, states, counties, city and counties, also have some power. Now, they're not inherently sovereign, so it's a little bit more limited. Okay, of course, and I'm sure you're familiar with this, is that the power of the federal government was broken up into three large blocks. Each block was supposed to represent a check on the other two. First, you had the Congress, that's set up in Article 1 of the Constitution. Then you had the executive branch, that's set up in Article 2, and you have the courts set up in Article 3. Then, to even give more check on the government, they placed limits on powers between the state and the federal government. And this is federalism, so they recognize that the states are going to have some power. So these articles, let's take Article 1, it's got some kind of procedural instances. So it's going to set up both the House of Representatives, which is popularly elected, 435 members, divided equally into the population. And then it's also got some inherent powers, like what can they do, where can they legislate. Same thing with the president and the courts. Now, where we get into some issues here is how do you read the Constitution? The U.S. Constitution of 1787, excuse me, is the oldest functioning written constitution on the planet. It is also the shortest. And anytime something is short, it doesn't necessarily mean it's concise. What it can mean is it's open to multiple interpretations as to what something means. And sometimes it would seem, well, it's pretty clear what this means. But is it really? Let's take, for example, an express power in the Constitution of the United States. The Constitution of the United States says, Congress shall have the power to declare war. Okay, well, that's a simple sentence. But does that mean that the president can't engage American troops without Congress approving? Is it a precondition? What about if it's a police action like Vietnam, or if it's sponsored by the United Nations like Korea, or if it's one of the ongoing conflicts in Afghanistan or Iraq that we've been in? I mean, we've been in Afghanistan now for going on 20 years, and there's no declaration of war. So it's often up to the courts to define, sometimes redefine, where the boundaries are inside the government and also between the state and the federal government. What can the state do? What can't the state do? Can the state regulate firearm ownership? That's it's an open question how much they can. All right, you read the Second Amendment of the Constitution of the United States. It calls for interpretation. I think it's usually fair to say that your federal rights are your floor. And by that I mean those are the minimum rights you're going to get. And your states can expand those rights, but they can't contract them. Now, generally, when we look at a division between state and national powers, we have, on one hand, the kind of strict constructionalists, sometimes called originalists, sometimes called textualists, and then those who believe in what's sometimes called a living constitution, or an open interpretation of the Constitution, one that changes. Now, let's look at some specific clauses inside the Constitution and how they could impact business. Article 4, Section 2. Now remember, Article 1 sets up the Congress, Article 2 sets up the executive, Article 3 the judiciary. Well, 4 starts talking about powers. So it says in Article 4, Section 2, citizens of each state shall be entitled to all the privileges and immunities in the several states. Now, again, subject to interpretation. What this has been interpreted to mean is it doesn't mean that states like North Carolina can't treat citizens from other states differently. But in some areas, they can treat them very different, and in other areas, they can't treat them differently at all. So here's a quick example. If you wanted to sue in Montana, and you were from North Carolina, and you had to file a fee, Montana couldn't say, well, if you're from North Carolina, your fee to file a court case is $500. And if you're from Montana, your fee to file that court case is $5. That would be impermissible. On the other hand, since state and local residents pay taxes to support local colleges or schools, the courts have deemed it to be acceptable to charge, if you are a North Carolinian and you're going to community college here, you might pay $500 a semester. But if you're from another state, you might pay $2,000 a semester. And if you're from out of state, if you go to UNC or a school, you might pay an even larger fee. And the courts have said that's okay. Another very important one, and this really applies to business, is full faith and credit. This is, again, Article 4, Section 1. And it just briefly says, Full faith and credit shall be given in each state to the public acts, the records, and judicial proceedings of every other state. Now, this applies only to civil matters, as it was read, but what it means is if you have a debt that's owed in North Carolina, that debt is collectible in Montana. If you have a right to property in Wisconsin, that right is going to be recognized in Louisiana. Perhaps the biggest power that the federal government has arises out of a relatively innocuous clause, and it's called the Commerce Clause. We find this in Article 1, Section 8 of the U.S. Constitution. Again, that's the one that sets up the legislative branch. And it says, it's the power of Congress to, quote, regulate commerce among the several states. So initially, this was kind of viewed that Congress could regulate if goods passed between the states. So if you had a steamboat that was moving apples between New York Harbor and Charleston Harbor, the federal government, under the Commerce Clause, could regulate that. They could tell you what kind of ship it was, whether they pay a fee. They could tell you all these things. This kind of changed in a very famous case. It's called the Steamboat Case, Gibbons v. Ogden. Comes down in 1824. And what it, and I don't really have time to go deeply into it, but basically it had to do with the right to operate a steamboat. Did the steamboat impact interstate commerce? And eventually, because of Gibbons v. Ogden, we say that the Commerce Clause lets the federal government regulate commerce, even commerce that is just inside a state, not between them. Today's application of Article 1, Section 8 is exceedingly broad. Almost any commercial activity is seen to be subject to regulation by the federal government. There have been a few recent boundaries to this, but it's still the primary mechanism through which we see the federal government pass and control business regulation. Here's a quick example how it impacts business again. In 1942, we were at war, and the federal government said, we want to regulate how people spend money to grow crops. We don't want you to use gasoline, which is in short supply, to grow crops, to sell. We want to tell you what you can grow. So we might have a need for wheat, or we might have a need for soybeans or this, but basically we want to regulate what you're growing. And in a case in 1942, a wheat farmer raised wheat on his land. He didn't sell it. He used it solely for his own use. He fed it to his own hogs. And he said, look, you can't regulate that behavior because it is not outside the United States, outside the state of Iowa or wherever it was. And the court said, yes, we can. And here's the logic they use, and this is why the Commerce Clause is so broad. They said, if you grew 1,000 bushels of wheat just for yourself and you use them just for your hogs, one of the things that's happening is you are not going into the marketplace and buying 1,000 bushel of wheat to feed your hogs. So that wheat you aren't buying might have been grown in Wisconsin or Louisiana or North Carolina. So you're impacting those states by not buying the wheat. They also said, of course, you're going to feed the hogs. If you slaughter the hogs and the hogs are sold, well, one of the ways those hogs were produced was through wheat. And that wheat, now that wheat is having an impact on the national marketplace. In 1964, the Supreme Court of the United States had a very thorny case. It's called the Heart of Atlanta Motel. And this was during segregation. And during segregation, many, many hotels, particularly in the South, and part of Atlanta, you can guess where it is, would not rent rooms to African Americans. They used the term back then, Negroes. So they claimed this isn't impacting interstate commerce. You could go up the street and get a hotel room, and maybe we don't even rent to anybody out of the state. So we're not impacting interstate commerce. And in 1964, the Supreme Court said, bull. you are interpat. So you cannot refuse to serve people because of their race. It's discriminatory. You don't have a choice. When you go into business, you have to abide by the rules we set. And you can't say, well, it's my business to do business who I want to do business with. And the court said, no. If the government says you can't discriminate against this group or that group, you can't refuse to do business with them. And if you do, you simply can't be in business. That's your choice. By making the choice to be in business, you surrender the full right of discretion. In 1995, we saw for the first time there were some limits. Congress tried to pass a law that banned the possession of firearms, guns, within 1,000 yards of a school. And the Supreme Court said, what's your authority to do that? And Congress said, Commerce Clause, and the Supreme Court said, it's not related to commerce, can't do it. Recently, we've seen a real fight with medical marijuana, and of course now legalized marijuana, because I think we've got 14 states that actually legalize it. Many states, including North Carolina, allow medical marijuana. Some states allow recreational marijuana, but here's the problem. The federal government bans it. Under the Controlled Substance Act, marijuana is, hold on to your hats, a Schedule I narcotic. It doesn't get any higher. It's on the same schedule with heroin. The federal government has held back on some enforcement here, but it appears it still has that power. So this is a good example of, well, how far in can the federal government go to what the states want to do? Courts have ruled the federal government have a positive power to regulate. They also, implicit in this is that the states can't regulate some activity. So one of the things that we worry about is a new state regulation going to place a substantial burden on interstate commerce? And that makes that act unconstitutional. And sometimes what a state is trying to do there is they're placing a regulation that is going to be discriminatory. There was actually a case here in North Carolina. Our old Commissioner of Agriculture, a man named Jim Graham, was fairly friendly with the apple growers of North Carolina. Now, North Carolina makes pretty nice apples, more heirloom type apples. They're not the big, shiny Honeycrisp or Red Delicious. So they were having some problems in competition, and they went to Jim Graham and they said, issue a regulation that would define apples in such a way that our apples here would get an advantage. And he did it. And he flat out admitted it when the court case came up. The regulation that he put on apples, size, distribution, weight, transport, all that, was really to favor North Carolina apples. And what the United States Supreme Court said was, well, you can't do that because that's interfering with interstate commerce. Now we're moving on to one that is somewhat problematical, but it's in Article 6. And it simply says that the Constitution and federal laws are, quote, the supreme law of the land, end quote. If there is a direct conflict between what the federal government says and what the state government says, the feds win because of the Supremacy Clause. Now, sometimes the federal government says, we're okay with the states operating in this area. They can have rules and regulations. An example here would be the EPA has standards for emissions. Well, most states have not adopted a different emission standard, but a couple states like California have adopted higher standards. And the feds have said, that's okay. If California wants to have a higher standard for protecting the air, if they want to put limits on what cars can spew out, then that's okay. So that's a concurrent power. Now, in some areas, the feds just preempted it. They've just taken it over. So, for example, nuclear reactors. The Nuclear Regulatory Commission, the NRC, is a federal agency which is charged with overseeing the safety of nuclear reactors. And by and large, the states are stuck with what the NRC wants. Now, sometimes it's hard to see whether it is a preemptive position where the feds are coming in saying no regulations from the states at all, or it's concurrent. So we do have to look in those cases at legislative intent. Well, here's a lot of people's favorite. Article 1, Section 8, Congress can, quote, lay and collect taxes, although this must be done in a uniform manner. We also have a later income tax amendment. So the power to tax is also the power to control and ultimately the power to destroy. Because one of the things Congress can do, and they did this with certain drugs, is, okay, we're going to make it a crime to possess and sell marijuana, but we're also going to tax it. And if you sell marijuana and you don't pay the marijuana tax, you have another issue. You owe money to the IRS. And see, there's a different play coming in here. It's kind of like the classic story that Al Capone didn't go to jail for killing people, even though he killed a lot. He went to jail for income tax evasion because he didn't pay taxes. Because, believe it or not, money earned illegally is taxable income. You rob a bank, you got to report that on your 1099. There is a federal special tax stamp issued in 1946 to grow marijuana. You had to pay so much money to grow marijuana. And theoretically, these still exist, although I haven't ever seen one, to be honest with you. All right, now let's talk about the Bill of Rights. There was opposition to the ratification of the Constitution, and in order to get it through, there were really two camps. They were called the Federalists and the Anti-Federalists. Federalists wanted to ratify the Constitution. The Anti-Federalists were against it. They had to agree that there was going to be some changes, and there were proposed amendments. There was a number of proposed amendments, but the first 10 are called the Bill of Rights. After the Civil War, so 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. After the Civil War, there have been a couple small changes about how the president was elected. We're up to the 13th, 14th, 15th Amendment. After the Civil War, we have the Civil War amendments, and what they started to do was they took those first 10 amendments, like freedom of speech or freedom of press, which initially were seen as only applying when the federal government acted. So what that would mean was the state of North Carolina could do something about freedom of speech, could restrict speech that the federal government could not. Well, after the 14th Amendment is passed, it is seen as incorporating the Bill of Rights and applying it to state actions. Now, this process didn't really get moving for almost 50 years, and it's not complete. You also need to realize when we talk about rights that rights are not absolute. There are always limits on rights. All right, so we got the First Amendment, which can impact business, obviously. The First Amendment has lots of things in it, but it will look at speech. And it will cover business speech. Now, how do we regulate speech? Well, the first thing to understand is that the Supreme Court places different limits on speech depending what the content of the speech is. If it is political speech, it enjoys almost absolute protection. There's almost nothing that you can do to regulate the content of political speech. On the other hand, commercial speech is much more subject to regulation. So I couldn't restrict you saying in a political speech, I think subsidies for tobacco is a great idea. But commercially, it'd be perfectly okay to say if you're going to sell tobacco, you're going to advertise it, you have to have a sticker on it that says this causes cancer. Commercial speech, if you can show a substantial government interest and that any regulation is advancing that interest and is limited to accomplishing that objective, is okay. Well, what about corporations? Do they have speech rights? They do. If it's commercial speech, it's regulated, but corporations also are, for want of a better word, people. There is also certain speech which is unprotected, again, assuming it is not related to political. Obscenities are not protected. Violent threats are not protected. And fighting words are what North Carolina says, words likely to produce immediate violent retaliation. Also in the First Amendment, we have freedom of religion. Now, there's really two parts of this. One is the Establishment Clause, which says we're going to separate the church and the state. It doesn't say that directly, but it's implied. And you can't support any particular church at the expense of any other. What it did allow is, and still does allow, if you donate to a church, you can take that amount off your taxes if it qualifies. It also has been used to support Sunday blue laws, which said things were closed on Sundays. It won't let you say, okay, you're running a parochial school that's run by the Catholic Church, great, you can get a credit from the state. Oh, you're running a state that's a madrasa, a Muslim? No, you don't get any money. You can't differentiate between religions. The Free Exercise Clause says that if you have a natural and sincerely held belief, that companies are supposed to make a reasonable accommodation to your belief. So an example here would be, let's suppose you are very religious and you do not work because of your religion between sundown on Saturday night till sunrise on Monday morning. Sunday is a day of rest. It's a commandment. I don't work that day. They have to make a reasonable accommodation to work with you. If they can't, however, you can be terminated. You are not absolutely protected. This free exercise is protected in the private realm much more than in the business realm. We'll skip over the Third Amendment. It's not very critical. The Fourth Amendment protects you against unreasonable searches and seizures. Before searching a private residence, and this is going to include a business, you are going to have a warrant and probable cause. Probable cause means I don't just have a suspicion, but I've got a good reason to believe I'm going to find evidence of crime or criminality. Usually, to enter a business, you need probable cause. Now, there are some industries exempt from this. Very heavily regulated industries, again, like nuclear power or some of the food safeties, in order to stay in that business, they have to waive their right to the Fourth Amendment. Border searches. When you enter or exit the U.S. border, the courts have said you have a lower expectation of privacy. We do not need a warrant to search you when you're coming in and out of the United States. This will include things like what's on your computer, even your browser history. Also, we have emergency situations where we don't give you a high expectation of privacy, where probable cause exists, there's not time to get a warrant. We also say that in certain areas you have less of a right of privacy. For example, when you're out driving your car in public. Moving on to the Fifth Amendment. Fifth Amendment is a big one. It doesn't generally cover corporations, so this is kind of a difference, but it does cover individuals. You cannot be compelled to give testimony that would incriminate yourself. You can't be compelled to testify against yourself. So if you're asked a question by the police or prosecutor and your answer would expose yourself to a criminal prosecution, you don't have to answer. Due process, and this goes to that 14th Amendment, a little bit of the 15th Amendment. I've talked about this. Procedural due process is the way in which a law is enforced. Substantive due process is the actual meaning of it. If a law impacts some fundamental right, that law is looked at with very great concern. In other words, a state must show a substantial reason for acting in a particular way. And if they can't, they're going to lose. This is why in the Obergefell case, where gay marriage became legal, why gay marriage bans failed. Quite simply, it was almost impossible to come up with a due process argument as to why you would not allow two consenting adults to form a marriage. You could come up with a religious argument, you just couldn't come up with a legal one. Also, we've got equal protection under the 14th Amendment. You can't deny any person within the jurisdiction equal protection of law. And this applies to both federal and state government. There are some different standards of review here. If the federal government says, we're going to review this regulation under the strict scrutiny test, that 99 times out of 100 means they're getting ready to strike down the law. If they say, we're going to look at it as an intermediate scrutiny test, is it substantially related? Well, it's much more likely that survives. And if they decide it only needs to be rationally related, that means they're going to uphold it. All right, privacy rights. Do you have a right of privacy? The first time you saw a right of privacy really being referred to by the Supreme Court was in 1928, when Justice Louis Brandeis said in Olmstead versus United States that there was some privacy. One of the first times you really see it applied is a fascinating case called Griswold v. Connecticut. It came down in 1965. In Griswold v. Connecticut, Connecticut had made it illegal for people to purchase birth control, prophylactic devices. And even married couples weren't allowed to buy it. So a married couple sued and said, look, we have a fundamental right to control whether we want to have children, and states should be able to do this. Connecticut said, we can regulate that. Why not? There's nothing in the Constitution that says anything about yay or nay. So it goes up to the Supreme Court. The Supreme Court said, if you take all of the rights, first, third, fourth, fifth, ninth, and you take them together, they create a penumbra or prenumber sometimes. It just means Latin for shadow. It creates a zone of privacy. And we're going to recognize that. So you have a fundamental right to birth control. In the 60s and 70s, quite a few laws were passed. One of the current hot issues affecting this is medical information. How much of that is controllable? And with this COVID epidemic, we're dealing with that. The Patriot Act, which is still reverberating, it gave massive new authority to the government to monitor personal records, particularly on a mega scale. Some state constitutions offer more protections. One of the more recent cases is Lawrence v. Texas, in which the Supreme Court of the United States voted to legalize not same-sex marriage, that's Obergefell. Lawrence v. Texas is homosexuality in the first place. Okay, on that note, at about 32 minutes in, about a half an hour is where I want to keep it. I will sign off, and I will see you for Chapter 5 whenever you're ready.